Welcome back to the Friday Five for September 1st, 2023. My name is Andrew Ayers. I'm a business law and estate planning attorney with offices in Edina, Minnesota, and New York City. As we get ready for the Labor Day holiday weekend, let's take a quick 5-minute look at 5 quick questions that came up in the last week with prospective clients and clients. Maybe these are things that you've had questions about as well. So, question number 1 this week: can I set up an LLC if I can't actually put my rental property into it? So in this situation, the prospective client has purchased a property that they're going to use to rent out. And I think they're actually going to use either Airbnb or VRBO to rent the property out. However, after they purchased the property, they put some money in to fix it up. They reached out to their mortgage company, a very important step in this process, and found out that the mortgage company will not allow them to move title to the property into the LLC. So the question they had was, can they still set up an LLC to run their Airbnb and or VRBO business for this property? And the simple answer is yes. You can still set up that LLC and you can run it like a business for your Airbnb property. What you can also do down the road is find out from your mortgage provider, will there come a time when you can move that property into the LLC? So we would prefer that the LLC own the property, but if it can't, you can still set up an LLC to be the business to manage your rentals. Question number 2, does a real estate contract need to be in writing? So in this situation, a client got into a deal with a friend of his, and the friend of his and they are working together on a rental property that they're going to rent out. And the question relates to how much of this has to be in writing. And the simple answer is as much as possible needs to be in writing, because when you don't have real estate contracts in writing and there ends up with a dispute between you and your friend down the road, without anything in writing, how do we know what's going to happen? How do we know what you actually agreed to? And of course, we're already at this point with this prospective client and his friend because they are coming to some disagreements about what they want to do with the property and who's going to pay what and what's going to happen down the road with paying certain expenses. So the question was, what can I do for him? How can I make the other person pay more money? And the simple answer is, especially when it comes to real estate, whether it's friends, family, or somebody you've never met before, you want your real estate contracts to be in writing. Question number 3 this week: how do I transfer an LLC interest while I'm going through a divorce? Now, this is going to come with the caveat that the answer is simply talk to your family law attorney. So if you're going through a divorce and you own an LLC, the question becomes whether or not that LLC is part of your marital estate. Is it something that the court's going to deal with as part of equitable distribution? Does your spouse have a right to a portion of your interest in that LLC, or is it something you started before the marriage, or is it something you started after you filed for divorce? These are all very fact-sensitive questions that you need to answer, but you need to answer with the help of your divorce attorney. You need to make sure you understand the implications of this. In this case, the prospective client was looking to sell his LLC interests to the other partners because he no longer wants to work in that company. But by doing so, his question is what happens to the proceeds from the sale, because it will be a significant amount of money. And he was concerned that his soon-to-be ex-wife would be entitled to a portion of that money. And the answer is to check with your divorce attorney and figure out how that asset is going to be handled as part of the divorce. Question number 4 this week: does my daughter need a healthcare power of attorney before heading back to college? So this time of year, when we get to late summer, we have a lot of clients who have children heading back to school for the fall semester. They can be just starting out, they can be finishing up. But once those children reach the age of 18, it's important to make sure they have the right documents in place. They may not need a full formal will, but powers of attorney can be very helpful to help manage their affairs in case something happens to them. So as a quick reminder, a healthcare power of attorney is a power of attorney that allows somebody to make healthcare decisions for you if you become sick and you're unable to speak for yourself. So commonly what I see is that my clients' children will have a healthcare power of attorney that they sign for their parents to be able to make medical decisions in case something happens to them while they're at college. You can also do a financial power of attorney, which allows you to manage their financial affairs. Now, again, the reality is most college students don't have a ton of money. They don't have anything they want to leave behind in a will. But the healthcare documents, a healthcare power of attorney, a HIPAA authorization can be very important parts of their toolbox to make sure that the right people are making decisions if something happens to them. And question number 5 this week: do I have to redo my entire estate plan if I have another child? This is a very common question I have because a lot of times clients will enter a will, or they'll make a will with me, and then a couple years down the road, they'll call up and say, by the way, we just had another child. Do we have to redo the entire will, or is there something else we can do? And the question is going to come down to, are there changes we need to make to the will significantly, or are they just small changes? So if it's simply we're just adding another child and all the provisions of the will are going to be the same, for example, I want to share my assets equally with my children, then you're fine because you've gone from 2 children to 3. So the share goes from 50-50 to 1/3, 1/3, 1/3. If we want to change a guardian, we can change a guardian for the children by using a codicil. If we need to change a trustee, same principle. We can use a codicil or an amendment to your trust. However, if adding the child means we're going to do something completely different, especially if this is your first child, then you will likely have to redo your will to make sure you have the right provisions in there to care for this child. Especially if the child was just born, you have another 18 years until they're an adult, and we want to make sure we have a plan in place for them so that there's no unlucky surprises for them if something happens to you and they're left behind without a guardian chosen for them and a trustee to manage their affairs. So those are our 5 questions for this week. We're getting ready for Labor Day weekend. If you like this video, you can hit the like or the thumbs up button below. You can subscribe to future videos on YouTube. You can submit a question at the link for future episodes. If you want more information about me and my firm, you can go to andrewmayers.com. And if you'd like to set up a chat, we can head to the legal strategy session button. You'll be taken to my calendar where we can set up a phone call. Wherever you are, I hope you have a wonderful holiday Labor Day weekend, and we will see you next week.